A very good morning, everyone, and welcome to today's conversation on emerging financial crime risks. I'm very excited to be your host today. My name is Mary Runana, and I take care of Financial Crime Compliance Unit at the Standard Chartered Bank, covering Kenya and East Africa. It is my true belief that fighting financial crime is a social imperative and is a responsibility of everyone, individuals, corporates, and government. Conversations like these help us bridge the gap amongst all the stakeholders and provide a platform for joint efforts in solving the financial crime problem. Today, we are privileged to have a distinguished panel of subject matter experts in matters financial crime who will help us unpack cybercrime, how it manifests itself, its convergence with other crimes, the COVID-19 impact, and best practice safeguards for individuals and corporations. We will also discuss trafficking crimes, why they matter, and what financial institutions specifically can do to disrupt these crimes. A few housekeeping. For a great experience, please mute your lines. Keep us engaged through the Q&A tabs. Our experts will be answering questions as we go along in the Q&A tab. And at the end of the session, we will pick up some questions for live discussions. Presentation materials will also be made available at a later date. Without further ado, allow me to welcome our keynote speaker, Justice Jane Okuo, to give us a view from the bench on the adjudication of money laundering cases in Uganda. Justice Okuo is a highly experienced legal practitioner and prosecutor with over 20 years of experience in this field. She is currently the head of international cooperation in the Office of the Director of Public Prosecution. It's such a pleasure to have you, Justice Okuo, with us. Please welcome and give us your remarks.
Thank you so much. I am extremely privileged to be here with you this morning. Just a little correction. I was the head of international cooperation while with the Office of the Director of Public Prosecutions. Following my appointment as a judge 2 years ago, I have been fully located and deployed at the Anti-Corruption Division of the High Court in Kampala. So I'm so thankful for this opportunity, and I will be sharing the experiences that we have at the Anti-Corruption Division of the High Court in the handling of cases of money laundering. And I would like to share the screen right now. Yes, so I just will begin with an introduction I will capture an introduction of the Anti-Corruption Court, its mandate, and then give the experience of the money laundering cases that have been registered at the court, and basically explain what the role of the court is. I will also take the chance to share a few of the challenges that we see from the bench in terms of prosecution and adjudication of cases of money laundering. Now, the role of the judiciary in countering money laundering and the financing of terrorism basically is the adjudication of the cases that are brought before it. The courts interpret, they apply the law, and the decisions which they hand down usually determine the meaning and the scope of the laws that have been enacted by the legislature. As far as money laundering is concerned, the function of the court also extends to post-conviction asset recovery measures and the issuing of orders during the pre-trial phase to facilitate investigation. And that basically covers searches and seizures and orders to restrain property. I also wish to state at this point that the role of the judiciary really falls, can I say, within the SDG 16.3, which basically provides that or requires states to reduce significantly illicit financial and arms flows and strengthen the recovery and return of stolen assets and combat all forms of organized crime. There is no doubt, it is not an issue, that criminals use money laundering to hide or conceal their crimes and ill-gotten benefits. And the Anti-Money Laundering Act of 2013, as amended, was enacted in order to combat and deal or control money laundering in Uganda. It sets out laws and regulations which accountable persons, banks, and financial institutions, among others, have to comply with to ensure that they are not aiding with money laundering. And it establishes criminal offenses and elaborate procedures for investigations. And that is where the courts come in. So the court tries accused persons that are charged with offenses of money laundering. If found guilty, it determines the appropriate sentence aimed at punishment and issues orders that take the benefit out of the crime. It also does consider the victims of crime and the need for compensation, while at the same time balancing the third-party interests as far as asset recovery measures are concerned. The Anti-Corruption Division of the High Court is the court that is vested with the jurisdiction to try money laundering cases. And it was set up by the Chief Justice Emeritus, Benjamin Odoki, under High Court Anti-Corruption Practice Directions, Legal Notice number 9 of 2009. And the intention of setting it up was to have an orderly, expeditious, efficient, and cost-effective forum for adjudication of corruption and corruption-related cases. It is situated in Kololo, Kampala, currently comprised of 3 judges and 4 magistrates. It employs the rules of procedure applicable in criminal trials, but the Anti-Corruption Court Act and the Anti-Money Laundering Act also provide specific procedures that are employed in adjudicating cases. The jurisdiction to try money laundering offenses under the Anti-Money Laundering Act is vested purely in the High Court. What that means is that the magistrate courts do not have the jurisdiction to entertain, bail, or even hear those cases. As a result, these cases have to be committed to the High Court for trial once the prosecutors are ready to take the matter for trial. But the process starts with the accused first appearing before the magistrate's court at the Anti-Corruption Division. To date, there are a growing number of cases of money laundering that have been registered at the court. From the time when the law was enacted in 2013 and then came into force, the first money laundering case in Uganda was registered at the court by the Office of the Director of Public Prosecutions in May 2015, quite a long while, you may say, after the law had actually come into force. And that's the case of Uganda versus Serwamba David Oke and 6 others. This case involved employees of Equity Bank and their relatives or agents and associates. And the case was concluded after 2 years, ending up in the conviction of 4 of the accused persons on 9 counts of money laundering. 2 years down the road, that was the first case concluded at the Anti-Corruption Court. I would say successfully as far as the intent of the law in getting accused persons and having them convicted is concerned. Since that time, the Anti-Corruption Court has concluded 3 other matters. Uganda versus Udaya and Tumwa. It involved an employee of KCB Bank. The case of Uganda versus Valentino Camia and 3 others. This one was concluded through a plea bargain. It involved an employee of the Swedish embassy, his wife, his parents-in-law, and all were convicted. And lastly, and only just recently, the court concluded the case of Uganda versus Malong, Lawrence Lual Yor, and 3 others. And that is so far the only acquittal that I have been able to see on the records at the Anti-Corruption Court for the offense of money laundering. The court also has issued several restraining orders, compensation orders for victims of crime, and orders for confiscation. As you may tell from what I have shared, our jurisprudence as a nation in the arena of money laundering is still low, it is still developing. Appeals have been lodged by the convicts in 2 of the cases outlined above from the information I have. Those hearings have been concluded and the Court of Appeal is set to deliver its judgments on notice. Now, the outcome of the Court of Appeal is highly anticipated. As you know, we believe that it will help us to build the body of jurisprudence that we have in our nation. The concept of money laundering is defined under the Anti-Money Laundering Act. It is the process of turning illegitimately obtained property into legitimate property and concealing or disguising the nature, the source, the location, or movement of the proceeds of crime. We know that the only reason that criminals engage in money laundering is their desire on the part of the perpetrators to conceal that they got a financial gain as a result of a criminal activity. These criminal activities could be illicit trade in wildlife, could be tax evasion, could be corruption, and a barrage of other criminal offenses that we refer to as the predicate offenses, which bring in the resources. In participating or engaging in money laundering activities, the perpetrators are able to avoid attracting attention of law enforcement agencies so that they are able to enjoy the proceeds of their criminal activity. The spectrum of the anti-money laundering legislation in Uganda under Section 3 as amended, specific criminal conduct or acts are, can I say, are legislated upon as constituting criminal conduct. And this is the bulk of the cases, or these are the cases that we receive at the Anti-Corruption Court. The activities that are criminalized under the law are the conversion, the transfer, the transport, the transmission of property believed to be a proceed of crime for the purpose of concealing or disguising the origin or of assisting any person who is involved in the commission to evade the legal consequences of their actions. Other actions are the concealment, the disguisement, or the impediment of the true nature, source, location, disposition of property, knowing or suspecting such property to be a proceed of crime. The acts are quite a number, and Section 3 lists them quite elaborately, and I will not go through each. The details would be in my presentation. Now, the common thread in most forms of money laundering under the Money Laundering Act, Anti-Money Laundering Act, is the concept of knowledge or having reason to believe that the property is a crime proceeds. The court, the Anti-Corruption Court, has applied Section 4 of the Anti-Money Laundering Act in analyzing the facts of each case and drawing inferences therefrom regarding proof of this element. And that section provides that knowledge, intent, or purpose required as an element of the crime is inferred from objective factual circumstances. And I will ask that in your free time, you can visit the legal information site. The judgment of Serwamba is available online. Now, most of the convictions that have been handed down by the Anti-Corruption Court relate to what was previously Section 116C of the Anti-Money Laundering Act, which criminalizes possession, use, acquisition of property with knowledge at the time of receipt that the property is a proceed of crime. Also under Section 116A, which criminalizes the conversion and the transfer of property for the purpose of concealing illicit origins in order to evade the consequences. If you consider those two provisions of the Anti-Corruption Act, you will find that they seem not to criminalize, they criminalize, can I say, the simpler forms of money laundering. And these are the cases that have actually appeared before the court. The question of possession or acquisition with knowledge that the property was a proceed of crime. And we know that in money laundering cases, they can be quite intricate with the whole process of placement, layering, and integration. And I want to state now that we have not had that kind of complexity of money laundering operations as far as Uganda is concerned. At least we have not seen them in the courts. In the recent case of Uganda versus Malong Lawrence, the accused persons were charged with obtaining money by false pretenses under the Penal Code Act. Additionally, they were charged with a money laundering offense. And in the determining that matter and arriving at a decision to acquit the accused persons on the charges of money laundering, the court noted that the charge was misconceived and that there was no evidence whatsoever of how the accused person embarked on using or administering the money so as to legitimize it, and that there must be action taken on the money to amount to the offense of money laundering. Otherwise, the action of obtaining itself cannot result in 2 counts. And the court observed that that amounted to double jeopardy, which is prohibited under the law. What am I saying? That the decisions of the court are available for all of us to look at and to consider, because Section 3C of the Anti-Money Laundering Act as amended, which is very similar to Section 116A and C, which I have talked about, have seemed to produce different results from the courts, and that raises an issue that I think we need to consider and resolve. We also know that money laundering is an offense that can stand on its own, and that you do not have to prove the predicate offense or even charge it. I mean, you don't have to charge the predicate offense for the court to make a finding in respect of the money laundering charge. In the experience of the Anti-Corruption Act, so far, I mean of the Anti-Money Laundering Act, so far we have had only one case that has brought a case without bringing the predicate offense as a crime, and that is the case of Udai and Tumwa. It was just one money laundering charge upon which the conviction was entered. I already stated that the common sources of money laundering crime process, according to the National Risk Assessment conducted in 2017, corruption takes the lead in Uganda, the offenses of embezzlement, diversion of public resources, causing of financial loss, etc., followed by tax crimes and fraud. Now, among the 4 money laundering cases that have been concluded at the Anti-Corruption Division, the predicate offenses in 3 of these cases are corruption, and in 1 it is a case of fraud, obtaining money by false pretense. So we have not had any money laundering offenses that come to the court outside of the corruption purview. In other words, nothing coming from trafficking in persons. I mean, nothing coming from trafficking in wildlife illicitly and those kind of other offenses. Now, I also want to indicate that apart from the offenses specified under Section 3 of the Anti-Money Laundering Act, there's another category of offenses that arises from failure to comply with obligations under the Anti-Money Laundering Act, especially by accountable persons. And the law covers this from Section 117 to 135 of the Anti-Money Laundering Act. The persons who are accountable are listed in the 2nd schedule to the Act. They include advocates who unfortunately have not registered as accountable persons from the information that I have, and casinos, real estate agents, insurance companies, banks, and financial institutions. I wish to point out that there are about 3 cases at the ACD, some still in the process, where 3 advocates have been charged under these provisions that I'm talking about for their role in the money laundering cases. involving their clients. One of these cases of Valentino Camia was withdrawn by the prosecution against the advocate when the plea bargain was entered, and it had also been reported to the court that the advocate went missing when he learned that the charges against him for money laundering had been preferred. We also have two ongoing cases at preliminary stages that involve advocates in money laundering. So the question of accountable persons is extremely key, and it's an area that we need to take note of, that those involved in handling cases at the bar are finding themselves called before the anti-corruption court for money laundering offenses. The methods of money laundering crimes, from what we've been able to ascertain from the cases that have come to the court, are one, the use of corporate vehicles. While companies have been credited for their contribution to rising prosperity in market-based economies, they are also prone to being misused for illicit purposes, including money laundering. They enable legitimate financial arrangements. They provide a wide range of commercial activities, including the control and movement of wealth and assets. And therefore, these companies provide opportunities for those involved in crime to own and manage property and to obscure the source of their wealth and hide their identity, allowing them to avoid detection by regulators and law enforcement agencies. In addition, companies are relatively cheap and easy to incorporate in our jurisdiction, making them an easy avenue for laundering purposes. And I will draw an example from the case of Uganda versus Valentino Camia and 3 others. In that case, the convict, who was an accountant to the Embassy of Sweden in Uganda, was convicted for embezzling about 8.4 billion Ugandan shillings, which he laundered through a sham company with the help of his wife and his parents-in-law. In order to conceal the ownership of multi-billion properties, the convict registered a company in the name of Shama Investment Limited, in which his mother-in-law and father-in-law were made the directors. The company had no physical presence, no activity. Its share capital was 1 million shillings. It was never paid up by its 2 subscribers, but it owned several properties in affluent areas of Kampala and Wakiso districts. None of the 2 directors knew the location of the company property, and all they used to do was to sign documents relating to these properties as and when they would be required. They also had bank accounts where huge sums of money stolen from the Swedish embassy and collections from rentals that he had registered in his name were put on those accounts. The parents-in-law, who were the directors, were peasants from Masindi. They did not know the source of the funds. Their role simply was to sign checks and withdraw funds. They were all eventually charged with money laundering. The accused, Mr. Camia, his wife, and his father and mother-in-law, and they pleaded guilty and were convicted through the plea bargain process. There's also, from the records that we see at the Anti-Corruption Court, the use of associates or third parties to disguise or conceal ownership. In the case of Camia, for example, one of the ways through which the accused person laundered the funds was using the joint account he operated with his wife. And the problem, which was the red flag that caused the investigation, was the fact that huge sums of money were transferred from embassy accounts to his wife's bank accounts. And this simplified the money trail that eventually led to the discovery of the transactions and the properties that he paid for on those accounts. Likewise, when he was arrested by the police, his wife tried to save some of the money by withdrawing it from the joint account and depositing it on the account of one of her close friends. And the sum of 250 million was traced. A restraining order was issued by court to prevent its dissipation. In the case of Serwamba David, we see the use of his associates. Actually, a lot of the money from the evidence before the court was given to his brother. And so the pattern seems to be that money laundering is drawing in not only the advocates, but also relatives, friends, and associates or confidence. And this is a signal of one thing, that Ugandans tend to hide property in the names of their relatives. We also have the use of advocates when criminals use shell companies, offshore bank accounts, and real estate as vehicles. The lawyers, whether knowingly or not, they assist in these transactions. I've already talked about the fact that an advocate in the Kamia case was used to register a shell company, handle the land transfers to the company name, and yet he was also the company secretary of the shell company that handled the transfers from the company to other names. So he was originally charged with facilitating money laundering, but as I said, the charges were withdrawn. Other common methods of money laundering that we see from the pattern in the courts is investing crime proceeds in real estate, the case of Serwamba David and Kamia Valentino. A lot of real estate in attractive affluent parts of Kampala were seized, and then also the use of shell companies. I also want to highlight that apart from the adjudication of cases, the court also has the power to issue orders seizing, freezing, and forfeiting assets in money laundering cases. And this actually has been very actively used by the prosecution agencies at the ACG. We receive quite a number of restraint orders to restrain, which are formal orders brought on application supported by affidavits. The Anti-Money Laundering Act provides for several other investigative mechanisms. Production orders, for example, section 44 to 48. To date, from the records that I have ascertained, none has been issued by this court. The law also allows for search warrants for documents, authorizing police to search and seize documents relevant to the location of property, section 49 to 55. Again, these applications have not been brought before the court. The law allows for monitoring orders, section 56 to 60 of the Anti-Money Laundering Act, where they can monitor an account of a suspicious, where there is a question or an investigation, where they move the court to allow them to monitor the account of somebody over a period of time. Again, we have not, I think, received any such application. The commonest are the restraining orders. The standard of proof is not beyond reasonable doubt. It is basically, as long as there are reasonable grounds, the court will issue the application. I don't want to go too much into that. I just want to explain that the standard that the court looks for when issuing a restraining order is that of reasonable belief of the deponent, the person bringing the application. It confirms the test of reasonableness in a Botswana case that is part of the work that the presentation that I will share with you later. You'll look at it in detail. But the court in Gaborone made a very important decision on the standard of proof and said that evidence and circumstances have to be looked at holistically by the court in determining whether there was material or evidence upon which the investigator, who is reasonable, having regard to the exercise of his mind, would entertain a belief that some crime has been committed. So the standard is not a very high standard on which the restraining orders have to be provided. I just want to, as I wind up, state that 4 money laundering cases have been concluded. There are very many more in the pipeline. The jurisprudence, as far as money laundering is concerned, is growing. There has been recovery of laundered funds through compensation orders, cases where accused have been found guilty. The court and the judiciary at large participates in the National Risk Assessment of Money Laundering and Terrorist Financing. We participated in 2017, and the division is even now participating in the ongoing National Risk Assessment and is being represented by one of the magistrates. Lastly, the challenges. Money laundering is a relatively new offense, and it presents challenges to both the investigators and the prosecutors in identifying what a money laundering offense is, or being able to identify that there is a money laundering scam going on. And this has resulted into the registration of a number of unsustainable money laundering cases at the court. In the case of Uganda versus Malone and others, the court did point out that that charge was misconceived, which means that that goes back to the evaluation of the prosecuting agency on what a money laundering offense is constituted of. Records show that a large number of money laundering charges collapse when, upon conclusion of investigations, evidence is found unsustainable. One recent example is the case of Nicholas Opio, in which prosecution had alleged that he had received through an Absa Garden City branch account 340,000 USD, knowing at the time that the funds were proceeds of crime. That case was withdrawn recently from the court. It never appeared before the High Court for trial. I also want to point out that money laundering cases are time-consuming due to their complexity, the involvement of syndicates. They are highly contested. In the case of Serwamba, I think there were 7 accused persons, and if I'm not mistaken, more than 10 advocates on the defense side, and I think about 4 prosecutors. So these cases are highly contested. They suffer orders from parallel civil courts that frustrate prosecutions or attempt to stall trials. And I will give an example of a miscellaneous application 27 of 2018. It was filed at the court by the Office of the DPP for a freezing order against the accounts of Sanders Exchange and Money Transfer Limited and others, while it conducted investigations. And this case never came to the High Court Division, ACD, for trial, because the Civil Division issued a ruling that stopped the prosecution one way or another. I must state, however, that the very complex and intricate money laundering cases involving the different layers of transactions aimed at concealing we have not seen them come to the courts. We can tell from the cases that we have that the tracing and identification of tainted assets is a complex matter, and I think that is understandable. We run a very highly informal financial system, and tracing of assets is not that easy. The issues of management of seized properties and assets is a challenge. Cross-border cooperation, again, challenges in respect to investigations and prosecutions. In the case of Serwamba, it involved money taken off an Equity Bank account from the Juba branch. And we had witnesses from South Sudan from whose account money had been taken. So the cross-border aspect in terms of bringing witnesses to the court here at Kololo, or using video link, which now I think many courts have, I know it poses a challenge, which the courts and I think even the prosecutors are trying to work around. We also see witness protection issues. There is no law on that in the country. I wish to conclude by stating that the sophistication and changing trends in the commission of money laundering crimes, it necessitates a continuous capacity improvement for judicial officers, and for members of the bar. It also requires a well-informed and an active bar, which is ready to challenge the actions of prosecutors and even the court decisions in order for the growth and improvement of our jurisprudence. Banks are extremely important. They are central in the movement of illicit financial flows. As you can tell from the cases that I have shared, I have pointed out KCB, I've pointed out Absa, which was a suspected matter that never got concluded. I have also through the other cases, all of them involve money moving through the banks. So the need for compliance with the anti-money laundering regulations and regime is extremely important. With that, I want to say thank you to you, ENSafrica, and I will be available.
Thank you. Thank you very much, Justice Okuo, for taking us through the developing jurisprudence for AML cases in Uganda, the challenges, and also calling us to action. That the accountable persons do have a huge responsibility in disrupting, reporting, and fighting, money laundering related crimes. Thank you very much. And without further ado, I would like to welcome Stephen Powell, who is going to take us through the cybercrime risks in Uganda and the safeguards that we can take. Stephen is the head of ENSafrica Forensics Department with over 30 years experience in financial crime risk management. He's a renowned specialist in white-collar crime prosecution, forensics lawyer, and specializes in leading forensic investigations that result in successful disciplinary and criminal proceedings. Thank you so much, Steve, for joining us. Please take us through this very interesting topic.
Thank you so much, Mary. I'm really excited to be here. This is part 3 of a series that has been run by ENSafrica with Standard Chartered Bank. And it's been an important initiative to create awareness of fraud, corruption, money laundering, as well as the cyber fraud risks in Uganda and mechanisms that need to be considered to address these risks. We've had a fascinating run so far with the prior 6 sessions, and today should be really exciting. And thank you so much for that opening address, Lady Justice Okuo. I think that you've given some very, very useful insights into the money laundering risks. And just from my side as an external forensic expert, the big challenge is enforcement. We've got to get more successful prosecutions. And I heard there were many sections that you referred to in the legislation that have not been utilized by the prosecution agencies. So we need to address that, and we need to show the rest of the world that money laundering risks are taken seriously in Uganda. The session that I'm going to deal with is going to focus on the managing cyber fraud, cyber crime, because while we've experienced this horrible pandemic, which has been a nightmare that if any of us were asked just 2 years ago, would we have ever dreamt that we would be in lockdown situations and going through vaccinations and having this horrible, horrible disease to deal with, we would have not dreamt of that. And today's session is just to warn about the other epidemic that has been proliferating in our societies globally, and that is the cyber fraud pandemic. Cybercrime has become the second largest threat after the pandemic, and the stats show that there's a near 300% global growth. And what has happened is hackers have taken advantage of the new normal uncertainties and remote working to spread malware embedded in malicious links. They try and lure us into clicking on these links, and phishing, smishing, and farming emails have proliferated to unprecedented levels. I'm going to walk you through what some of those entail and what they mean, just so that there is a general understanding of these concerns. And as Mary said, the materials will all be made available to you. So you'll get these slides. And I know my colleagues Adam and Godfrey have also got some nice materials that they're going to be sharing on the threat and how to manage cyber fraud and cybercrime risks. Organizations have had to invest millions in strengthening and improving ICT resources and cybersecurity strategies to ensure business continuity. And what we've seen is that many organizations have had to start from scratch to build capacity to deal with this threat. And you'll see from some of the studies that almost every organization has been impacted by cybercrime. Uganda has been very active in managing data privacy. Uganda passed the Data Protection and Privacy Act. We referred to that as the DPP Act in May in 2019. The regulations in May 2021, and the Act and regulations are intended to support privacy protections which are already guaranteed to Ugandans under the Constitution, and they're designed to complement sectoral laws for regulated activities that had previously incorporated data protection provisions. I'm going to run through the types of attacks that are taking place on individuals. We have a lot of social engineering and social media, Facebook, and all of these different social media sites that we utilize are being used by criminals to gain access to your personal or confidential information. And we need to address that. And you'll see one of the messages from me is that we need to be more cautious about what we share on social media sites, because we need to just understand criminals are watching our movements and they're trying to get information so that they can commit identity theft and they can impersonate you and they can go and open accounts and do transactions pretending to be you. Phishing is where criminals attempt to trick unsuspecting individuals into clicking on a malicious URL or email attachment to steal their login details, which they then use to gain access to your financial accounts. And if you click on one of these links and you give them your password, literally within minutes, they'll be transacting on your account. And by the time you realize it and contact your bank, the fraudsters have already emptied your accounts. Phishing is when a fraudster phones a victim posing as a bank official or service provider and uses social engineering skills to manipulate them into disclosing confidential information. The banks send messages and they try and create awareness constantly to their clients that they will never phone them and ask for their password details or login details. So whenever you get those requests, be very nervous, because it is usually a fraudster that you're talking to. Phishing, it's the abbreviation for SMS phishing, where criminals send an SMS purporting to be from your bank requesting your personal or financial info, such as your account or PIN number. Farming is a cyber attack intended to redirect a website's traffic to another fake site. And farming is conducted by changing the host file on a victim's computer or by exploiting a vulnerability in the DNS server software. Ransomware, Adam's going to go into great detail explaining this prevalent threat. And then the other fraud proliferating is online deposit scams. So whenever you get promised, work from home, get rich quick schemes, and you have to pay something up front, we refer to these as online deposit scams. There's a puppy scam. I've noticed some clients have bought beautiful dogs that they've fallen in love with on the internet. They've shown a picture and the children all love the dog and they're told that it's an exotic breed. It's going to cost $10,000 or $5,000. And once you make that payment, the next thing you're going to get is a further request for veterinary fees or transport fees, because there will have to be a special cage built. And wherever you live, the dog will come from a different region. So, and people spend because they become emotionally attached to this fictitious dog. So we call those the puppy scams. And then the one that I'll go into a bit more detail on later is the man in the middle or business email compromise fraud, which is prevalent at the moment. And I'll give you some useful tips on how to manage and fight that. And then the last thing is the 419 scams. And we'll show you a few examples of all of these. When I was preparing for the session, I just looked at a Uganda police report, and I identified that in Uganda, the types of frauds that are prevalent, cyber frauds that are prevalent, is fraudulent SIM card registration and SIM card swapping, where the fraudsters get access to the SMS from the bank when you're transacting. Online impersonation of high-profile personalities, which is just another form of ID theft. Unauthorized accessing of accounts, so hacking, remote access vulnerabilities, because what happens when we work remotely is there's less supervision and it's a lot easier for the fraudsters to penetrate and get up to mischief. And then I've spoken about the phishing, farming, etc. with the malware, and there's a lot of abuse of privileges. So we've got to make sure that we only allow rights on our system to users who need to have those rights. So privilege abuse is another area that the Ugandan police have been occupied with. Database manipulation, business email compromise, social engineering. And we've seen a massive increase in cyber stalking and cyber bullying. Identity theft is rampant everywhere on the globe, and particularly I find in Africa. And what happens is the syndicates have, we call them ID factories, where they build ID documents and they put in the pictures and photographs of the fraudsters, and then they use that false documents in terms of death certificates, marriage certificates, letters of executorship, salary advice, municipal bill, bank statements, or login details. What do they do with this? They create these authentic looking documents. So they open new retail or credit card accounts, and you don't even know that you have an account opened by a fraudster in your name. And the first you hear about it is when you start getting arrested for not paying the account for things you never ever bought. They also submit false claims, or they redeem investments. We've done a spate of redemptions of investments where the syndicates pretend to be the customer. They gain access, they penetrate email, Gmail accounts, and there you've got to make sure that you change your passwords regularly and don't use simple passwords, don't use family members, pet names, or children's dates of birth, etc., because those are easy for the syndicates to try. And they also do false insurance claims or medical aid claims. They impersonate you and attempt to transact in your name. And the one that's been quite prevalent as well is that they infiltrate the revenue authority. They get hold of their colleagues or friends, and they find out when there are tax refunds due to individuals or entities. And the next thing they do is they pretend to be the customer, and they change the bank account and the address details of the customer so that when that refund is paid out, it goes to the wrong account. These are some of the examples of the attacks on individuals with these SMSs where you get rewarded. There's a prize that you've won. To view details, click here, and it's a malicious URL. So you never click that, or there's a number that you must phone, and it's just the syndicates trying to get hold of your personal information so they can commit fraud. And here's some examples of the phishing and farming. Dear valued customer, the transaction paid into your account was unsuccessful. To continue, please proceed now. For more info, click here. And if you click that, you click in on a malicious link. There's an example of the SARS, the Revenue Authority. And again, this one is encouraging someone to click and put in their details, and then the syndicates will transact. What is also happening, and this one is really prevalent, is business email compromise, man-in-the-middle attacks. Invoices are intercepted in the mail, and they take an accounting firm or law firm or any service provider's invoice, and the fraudsters clone it, but they make a few changes to the cloned document. What are they going to change? They're going to change the bank details. So if I have employed Deloitte to do some accounting for me, I'm expecting a bill for $10,000. I get the invoice in the mail. I see the amount is $10,000. I see that is exactly what we owe. We know that they did the work. We process that, and we process payment to the account on the invoice. But often that is a different account to the one that we're used to dealing with. So the fraudsters have cloned the invoice, but they've changed the bank account. The other two items that are critical clues to an intercepted and fraudulently changed invoice is usually they will put the contact number as a cell number. Corporates always have a landline as well as a cell number. It's very seldom that they only use a cell number. So that's sometimes a giveaway. And then the other important clue is that when the fraudsters send this, the other contact detail of the recipient will be a Gmail address. Corporates seldom use Gmail addresses as their corporate email address. So when you see a Gmail address on a corporate invoice, be very nervous. It's probably fraudulent. And then the big clue is often what happens is the syndicates will send an email attaching the fraudulent invoice, and they will pretend to be from the entity. So I mentioned Deloitte in my example. So they will change, instead of Deloitte, it will be D and T and the address, or they will take out some of the letters in the name. So they will misspell Deloitte, and it won't have the E on the end. And if you hover your mouse over the address on the email, often it will throw out the alias behind that address, and you'll see that it's coming from a Gmail address or a Yahoo Mail address. And those are critical clues. So whenever you get a request to pay into a different bank account to what you used to paying for that service provider, be very, very nervous. It's probably a fraud. How do we minimize the risks? We've got to be very selective with the type of info we share on social media sites. Use strong passwords and never write them down or put them in your diary in the top or bottom drawer of your desk, because that's the first place syndicates are going to look to find and identify your password. Don't share your password with your colleagues also, because I know people trust their colleagues, but the risk is once you give your password away, someone else can transact in your name. Only use reputable online shopping sites and look at the all on the website. If it begins with HTTPS instead of HTTP, it means the site is secure, and check with friends if they've heard it before. Don't just log on and pay to a new site. Be extra cautious when you use Wi-Fi hotspots. The fraudsters set up sites in the airports and they offer free Wi-Fi, and everyone wants something for free. So we're quick to click on this link to get the free Wi-Fi, and the fraudsters can monitor every step that we take on that site that they will host. So don't click on random links. And names of children, places of employment, places you frequent, your Facebook check-ins, birth dates, all of these are accessed by syndicates. And when you post pictures of your holidays in the tropical islands, everyone is doing these selfies all the time. You broadcast into the syndicate that you're away from your desk. We did a case recently with a CFO who was in the middle of a big merger transaction, and the syndicate sent an urgent message that they need to accelerate payment, and we need to pay a deposit, and the deposit of $400 million on this big M&A transaction must go into the following account. If we don't get it paid within 24 hours, the seller is going to walk away from the transaction. And they did it because they picked up from the social media that the CFO was on leave. Fortunately, he answered his phone in the middle of the night, and they asked him to confirm this request. And he said, "What are you talking about? This is absolute fiction." And make sure your privacy settings are updated. The last thing I'm going to wrap up with is just what we call EFT fraud. And this is a type of fraud that all organizations need to be aware of. Procurement is costing more than we realize, because with EFT fraud, we think we're paying our suppliers, but actually what has happened is our employees in our finance, in our accounts, in our procurement teams, is they are going onto the system and changing the bank accounts of our vendors. And when we make the payment of $10,000 to a vendor that we owe the $10,000 to, we think we've paid a vendor, but actually we've paid the partner or the boyfriend of our employee, and that account has been manipulated. So usually what happens with EFT fraud is the employee creates a false vendor with their own account or their friend's account number. And when they want to pay fraudulently, they do an EFT transfer to that fraudulent account. The other one that they do is they go onto the system and they delete the real details of the vendor, put in their intended beneficiary, themselves or their family or friends, do the transaction, then they delete the fraudulent details off the system and put the account details back to what it was originally. And those are things that companies should be checking and screening for. So I've got a couple of examples of this. We did one with an FD who stole 4 million South African rand, and he stole 1.7 million in one morning. And we caught him, he cooperated, he went to jail in South Africa for 5 years. We had another one with a lady who did that type of EFT fraud, but she also put stop orders on the bank account of our organization for her private expenditure for satellite television, cars, telephone, insurance, and even paid for the cars on a stop order. So companies have to make sure that they monitor their accounts and they check that there's no irregular transactions. There are a number of things that companies need to do to prevent EFT fraud. So make sure that you vet vendors properly, make sure that they are genuine, they've got the expertise, and if there are changes to bank accounts, be very nervous. Organizations don't often change their bank accounts. So verify, validate, and if there have been more than just a handful of changes to bank accounts in the last year, you've probably had this type of EFT fraud. So thank you, everyone. It's a short period of time. Over to the next speaker. Thank you, Mary.
Thank you very much, Steve. I mean, you really unpacked the cybercrime risks that we see. Great examples and simple tips of how we can prevent ourselves. I think the critical bit is to know that as our personal data is trailing across the digital and social media platforms, then somebody's watching, and the cybercrime syndicates might take advantage of that. Now over to Adam. Adam will help us understand the convergence of cybercrime with other forms of crime, and also some challenges that we have in tackling cybercrime. He is a highly experienced cybersecurity and risk expert, and currently is heading the Standard Chartered's group cyber financial intelligence unit. Just a quick note, please ask your questions in the Q&A. I've been trying to check whether there are any questions that are coming through, none so far. Feel free to engage us, but also just to note that the presentations will be available to you at a later date. So over to you, Adam.
Hello, everyone. Thank you so much for inviting me to talk to you. I hope you can hear me okay. And I'm also hoping you'll be able to see my presentation. So thank you very much. Again, it's an honor to follow the Justice and Stephen doing two great opening presentations that have really set the scene in terms of AML, corruption, and cyber. So thank you very much for doing the hard work and making my presentation a lot easier to make. So a little bit there that Mary touched on. My role is a little bit unusual, perhaps, for many people when they think about cyber. I actually sit in our financial crime compliance function rather than our technical security function. My background combines both. I worked in what I'll call pure cyber threat intelligence prior to this role. And actually, one of the reasons, hopefully my presentation will become clear, is how important the financial side of cybercrime is. And exactly what we can do about it, some of the challenges, and expanding a bit on some of the things Stephen mentioned and what we're seeing threatening us from the financial sector and some of the challenges they bring. So hopefully I can share this screen. Hopefully it's moving along good for you all. So this is a little summary of what I'm going to talk about. I won't spend too long on it because I'm very conscious of time and you want to get on to the exciting stuff. So I think it's important for me to set the scene. Stephen outlined some of those cyber-related attack vectors and really how easy it is to compromise you. But when we think about it from, if you like, a financial crime perspective or a fraud perspective, we kind of break this down into two ways of thinking. You've got cyber-enabled crime and cyber-dependent. Cyber-enabled are, I'll say, traditional criminal activity or predicate offences, such as the Justice was talking around, that are now enabled by cyber. And really, the narrative is this touches all kinds of criminality. Probably a good example maybe is drugs trafficking. Back in the day, it's hard to imagine now. It's hard to even think about life before the internet. But you'd have to meet face to face on a street corner and organise a network to exchange the drugs for cash. Now you can do that on an online dark web marketplace. So it makes it a lot easier to facilitate the crime. And then on the other side of this, we have cyber dependent. So criminal activity that couldn't have happened until we've had our digital lives. And ransomware may be a good example. I'm going to talk a little bit more in depth about that. But some of the issues Stephen were talking around, actually the technical compromise of devices, machines and bank accounts that just you couldn't have done that before the internet. And on this slide, we talk a little bit about some of those predicate offences and how cyber is affecting them. But again, the main thing you need to take away here is it touches all kinds of criminal activity. And again, this is a little bit of an expansion about about actually how does cybercrime really touch the financial sector. So not only does it facilitate the predicate offences in actually committing the criminal activity, it's actually really important now in terms of the money laundering side of this. And on this slide, the way we just really focus it is on money mules. If you think about, again, the world before the digital life we lead, you'd need like physical people to move the money, physical attending branches to put cash into bank accounts, funnel accounts, etc. Those techniques still exist, but now you have an extra way of doing money muling. You're able to technically compromise, maybe using one of the techniques that Stephen outlined, to compromise your online banking account and move funds through it or steal funds from it. So actually, it really has increased the potential to conduct money laundering activities. So again, hopefully that's a useful, very short insight, but actually don't forget how important cyber crime can be to facilitating money laundering activity. So hopefully I've outlined a bit there about how you've got cybercrime facilitating predicate offences, but also how it affects banking and money laundering. So what does this mean for us as a financial institution? There are some obvious challenges here. If you think about the way many organizations, you have technical guys who are worrying about perimeter security, and you've got your financial crime compliance experts sitting in another part of the house doing their financial crime analysis, looking at transactions and reporting it to regulators. In short, the challenges of those skills haven't always been complementary, but we're moving into a world where actually we need professionals to understand both sides. And that doesn't mean you have to reverse engineer malware technically to analyze it, but you have to understand some of the key issues and some of the key developments to really deal with the financial crime and meet regulators' expectations. Okay, I finally managed to move the slide on. And I think one of the other key challenges we're facing is actually the rapid development, I'll say, of the financial sector, but in terms of the way that we may move money and some of the tools, products and services that banking institutions or wider financial services are providing. And this actually changes the dynamic of some of the layering, some of the factors in money laundering. Some of you, I'm sure, will be well aware of some of these steps: placement, layering and integration, which is crucial for the criminals, as the justice outlined, to try and get their ill-gotten gains. So actually, some of the things we're seeing is the demand from the public. People want quicker payments. People want easier payments. People don't want to have to walk into a branch. So you're finding financial services, traditional banks like Standard Chartered providing those services, but also new entrants and new players, thinking of digital wallets here, money service bureaus moving into this space. They're providing tooling and capability to meet that demand. But all of those factors can have security implications. And if you think about it simply about the expectation of a speed of payment, you want that payment to be made and to complete quickly, to buy your good or to share it with whoever your friends and family are paying. But the quicker that payment is made, that poses challenges if, for instance, you're an unfortunate victim for one of the scams that Stephen was outlining. How can we recall that payment? It's moved so quickly, the criminals will move the money as fast. So it actually causes us some control, process and procedure challenges to meet that. So I think one of the key features for financial institutions is to try and always embed security in your new products and services. It's a very easy thing to say, but it's actually been very challenging, particularly with the speed of change that we're facing. So I think, we've mentioned COVID already a couple of times. I think we can't underestimate the upheaval it's caused to us socially. I think one of the really interesting dynamics, and Stephen touched upon it, is how much upheaval that has made. And I think one of the great examples is lockdowns and the rapid, almost instantaneous change to people working from home. And many organizations that maybe allowed this rarely, suddenly having to have their whole workforce working from home. That really did provide a lot of opportunities for cyber criminals to leverage that. If you think about cybercrime, their ultimate goal for most cyber criminal activity, and I'd say nearly all actually, even some of what you might call cyber espionage, which I'll also touch on in a moment, is financially motivated. So they will act quicker. They don't have the regulations. They don't have to worry about policies and procedures, and they can share data freely without restriction between each other because they're just looking for financial gain. They don't have some of the obligations that law-abiding organizations and individuals would face. So they move quickly into this. And when we were like analyzing this at Standard Chartered, you know, we could see this social disruption causing problems. Suddenly everyone working from home, you're leaving the kind of organizational network and you're moving into leveraging actually people's personal routers, for instance, for internet access. And on that, all that growth of devices being used provides potential opportunities for cyber criminals to attack individuals and organizations. And the disruption did cause challenges to cyber criminals. They had to rapidly change, but as I mentioned, they're pretty much used to doing it. Whenever there's a new development, product, service, they will move quicker than anyone else because they have to. It's their livelihood to steal funds using cybercrime. But I think it's also important, you know, 18 months, 20 months in, what did we actually see? There was a lot of fear and focus about cyber fraud, a lot of concern that you had to react very quickly. There's going to be a rapid increase in fraud, leveraging things from fake PPE, companies popping up who've never supplied personal protection, personal protective equipment before, and then you've got these government support schemes set up to support companies who are struggling because of the pandemic, and the cyber criminals moving into that space. So a lot of focus on that activity, and I'm sure a lot of financial institutions and law enforcement looked at that activity very strongly and looked to try and get ahead of the game. But actually, I think one of the key factors that I think people need to take away is actually this doesn't really change. The fraudsters really use COVID as the hook, the social engineering lure, to entice you to click on that link. You might get that SMS message, as Stephen was outlining, that had a COVID-related theme, and people were desperate for information. So they were very good at leveraging that. We did see it, but overall, fraud didn't increase that much. The focus of it became COVID. And I think that's kind of a scary thing to think about, that fraud is that prevalent. You know, we didn't see a dramatic increase. We just saw COVID as a social engineering lure. And there's a couple of examples on this slide that I won't have time to go through too much, but I think the one on the right, lessons from history, the unfortunate Ebola crisis. Again, we saw some of the similar techniques being used back then. So not everything was new. There's a lot we can learn from past events. And I think one of the key things is learning from what happened in this pandemic and really looking to embed that for future crises, because there will be some. So ransomware, it's probably the sexiest cyber crime, if you like, or cyber topic at the moment. It's certainly one of the things that's grown most dramatically. So as I touched on earlier, ransomware is when an attacker will compromise the device or system, usually targeting an organization, but not always, and then encrypt the files and data on that system so that the victim can't access their own data or information, and they will demand a ransom payment for that. Often that ransom payment in cryptocurrency, actually. And obviously that can be, that's a very interesting dynamic. Regulators are looking at this as well to try and understand what the expectations would be. But one of the key factors here is that, yes, it's a very technical attack. Obviously the ability to put that malware, malicious software on the device or system. Creating that malicious software is going to take highly skilled individuals, but there's a criminal marketplace. Actually, people trade this software, and people will sell the ransomware they've developed to the highest bidder, or a bidder that meets their price, and they can then, you know, deploy that against their target. But something I do want to emphasize, why that's highly technical, the creation of that malware, and you're going to have a, if you like, a supply chain of cyber criminal expertise to build that attack underneath. The actual delivery of it, it's still often dependent on some of those key things that were outlined earlier. Somebody clicking on that phishing email link, somebody browsing to the web page, somebody not noticing it's not HTTPS, and they've been on what's called a watering hole or drive-by, and that's compromised the system or device. So there can be very technical ways of doing it, things called zero-day exploiting on vulnerabilities in software. But still, nearly always, the main way of attacking this is through some of those most common techniques, leveraging people making a mistake. So it can be quite scary, but the most important way of defending yourselves and your organization is to focus on those key controls, the things you can do, the critical security controls. And I think ransomware is challenging because of the cryptocurrency side, and also some of the concerns around who some of the entities are behind these attacks. So nation state related activity is something that's particularly been in focus with some of the regulators. And there's always concerns around any of these payments reaching sanctioned entities or countries. So it is a pretty live space. And I think one of the challenges, even though law enforcement won't want you to pay, you need your data to operate. So it is a particularly scary type of attack. But again, the focus is concentrate on those critical, if you like, the simplest controls, training staff and clients, so that people don't click on those links. Just a little bit conscious of time again, so apologies. Hopefully you'll be able to share the deck after this. But many of the ransomware payments are demanded in cryptocurrencies or crypto assets, depending on how you want to call them. There's a perception, quite common one, that they're anonymous, that you can't trace activity, and criminals have favored them. The fact that there's a reason that ransomware payments are demanded in cryptocurrencies. But for many of them, you can trace this activity from the first transaction to the latest one made. It's a huge opportunity to do that through blockchain analysis tools, which look at the protocol of the crypto asset to be able to tie them certain addresses, certain payment addresses in the crypto asset ecosystem together, and also using open source intelligence and other sources and tooling to actually connect those addresses to real world entities. And there's been some real success, actually, particularly a ransomware attack recently in the US, where law enforcement was able to identify where the funds went and recover them. So it's a real good example of actually what you can do with blockchain analysis and following cryptocurrency transactions. Can't spend too long on it, but I think there's actually a lot of opportunity here with the right tooling and training. So advanced threats, what can be known as advanced persistent threats, APTs. Essentially, these are the most sophisticated actors, often associated with nation state countries, cyber espionage, cyber warfare. I think there's a perception that actually in a lot of cyber attacks that they won't come after you. I'm just a secretary working to the CEO. They won't be interested in me. My company does nothing directly involved in the government, but we might be trading internationally. But so we don't think we'll be of interest. But actually, don't underestimate the level and scope of interest that these I'll say attack groups may have. Don't want to scare you too much, but within Africa, Uganda, we've seen reported attacks against a whole range of institutions, not just government entities, charities, educational institutions, telecoms, companies, and financial services. So the whole range of information can be of interest and use to these groups. And we think about espionage, spying, stealing information, but actually a lot of this data and a lot of these groups may on the side sell the data, trade it to other cyber criminal groups, so then to leverage it for their attack planning, or to actually potentially steal money or compromise your systems further down the line. So there is an integrated ecosystem. Cyber criminal groups don't work in silos, and many of the individuals in those kind of groups will work for many different others. So it's definitely something to bear in mind. And actually, even though that's a little bit scary, they most often will try and compromise the system or access it by the same tools and techniques that Stephen outlined. Getting someone to click the phishing email, getting someone to go to the watering hole site. That's still the route into the system or device. And I don't think I can underestimate how important it is to raise awareness and to take the simple steps, which will probably prevent 90+% of these types of attacks. And I actually got here on the right of the screen an advisory, and it was interesting just because it came from the US government, but it came in the middle of this COVID pandemic. I kind of touched upon how the focus was that we all have to focus on COVID fraud, but actually one of the key aspects is this advisory came out in the middle of that, basically saying, don't forget this type of attack. And And one of the crucial things is it emphasized, it's not just about the technical controls. A lot of this is about what you can do to prevent successful cyber attacks, is looking at your controls, your AML controls, your money laundering controls, and actually stopping the money flowing. Because if you can stop the money, the attackers will lose interest. It is an extension of the ability of ours to stop cyber attackers being successful. Don't forget the money, and don't forget stopping the money is so important. So I think it was a really interesting dynamic. I put here a slide. I know I've gone through that very quickly, saying any questions, just conscious, I'll have a quick look. Oh, there is some in the Q&A. So I'll try and get through these quickly. How does the financial industry ensure that...
May I request that we do the questions after Gibbs has given his view on trafficking, but also as a promise to the delegates, we can actually answer the questions on the Q&A tab. I've seen questions on mobile device malware, risks associated with the Internet of Things, guidance on insurance products for cyber risks. For the panelists, Steve, Adam, please feel free to answer this in the Q&A session. And Gibbs, maybe kindly you can quickly take us through why trafficking crimes are important, for us, and especially what financial institutions can do. Thank you. I can see a lot of engagement in the chat. Everyone is very happy with the sessions, they are getting it. And I think the critical ask that I'm seeing is that we provide the materials after the presentation, and we will endeavor to do that. So Gibbs, over to you.
Thank you, Mary. Thank you all the presenters. It's been a great presentation. I think it touched some tenants who are fighting as a country. I'll briefly summarize illegal world trade, that Uganda is a rich home of flora and fauna, which is largely found within protected conservation areas. But despite that, Uganda still plays an important role in the global trade of illicit wildlife trade. Evidence from arrests and seizures has increasingly confirmed that the country's status as a major transit and logistic hub through which wildlife products are trafficked from Central and East Africa to Asia. And in particular, Uganda has been heavily implicated in the illegal trade of elephant ivory, which has led to its designation as a country of primary concern by the Convention on International Trade in Endangered Species. As you all note, we have seen in this mainstream media in recent times where the police have arrested individuals involved in ivory and horns. But this is also facilitated together with the country's geographical location. The illicit activities are enabled by a number of factors. For example, corruption, the presence of highly organized criminal networks, and with national and transactional reach, as well as growing demand for certain wildlife productivities, majorly including ivory and pangolin scales in East and Southeast Asia. And also, we can't do away with the weaknesses in the design and enforcement of the current legislation in place, which does not clearly enable the management of these crimes. And this is majorly driven, of course, by the high profit margins, low risk of detection, low rates of conviction, and low levels of penalties, and officials colliding with the people involved in the wildlife crime as an attractive prospect for poachers and the criminal networks behind them. So for me, the key message in this area is, why do we as a bank and stakeholders involved need to fight illegal world trafficking as a country and at large at a global level. One is that we have a role to play in disrupting the illegal wildlife trade by identifying related financial flows, and we make this a priority across the industry. Secondly, we have a duty to identify and report potential money laundering linked with illegal wildlife trade. As we are all aware, illegal wildlife trade is a predicate offense for money laundering under the current legal regime in the country. Secondly, there is no one-size-fits-it-all approach to investigations. So as stakeholders, we need to have the right mindset. We need to be alert and we need to be diligent and use our own common sense in identifying these illegal wildlife trade activities across the country. Of course, key is what we are doing now, raise awareness among all the stakeholders across the board to ensure that we share information and intelligence in management of this heinous crime. As a bank, we strive to partner with other banks, law enforcement agencies, and subject matter experts, like today we are doing, when appropriate, including non-government organizations, to ensure that we are all at the same page in terms of managing this heinous crime of illegal wildlife trade. I want to conclude on wildlife trade by saying that illegal trade in wildlife is eroding the Earth's precious biodiversity, robbing us of our natural heritage and driving whole species to the brink of extinction. The killing and smuggling is also undermining economies and ecosystems, fueling organized crime and feeding corruption and insecurity across the globe. More people need to understand the damage this illicit business is doing to our environment, livelihoods, communities, and security. We must change our habits and behavior so that the demand for illegal wildlife products falls. In relation to the human trafficking, again, human trafficking is a silent crime, and the money laundering is silent.
Gibbs, I think there's a bit of a connectivity issue.
For accusation of thing and the Middle East.
Gibbs?
Can you hear? Mary, am I loud and clear?
No, you're not. I think you're breaking, but thank you so much, I think, for the points that you raised and your closing remark, especially on the illegal, wildlife trade. That and I like especially the way you've concluded that it's not a one person's job. We need to appreciate the risk and the impact of this crime. And I think because of time, probably I can read just one question because I've seen quite a bit of questions coming through on the cybersecurity front. So we can answer one live before we close the session. And then I believe that we will give our participants the materials and we will continue with this conversation. I think there is one here. I don't know whether Steve or Adam, you can take it. Kindly guide on the risks associated with payment gateways, especially where BIN services are shared to facilitate card payments. So either Steve or Adam, please feel free to take that question.
Thanks. I'll hand that one to Adam Mary from the Bank Inside. I think he's best placed.
Okay.
That's fair enough, Stephen. So it is a challenge, actually. I kind of touched upon that, this isn't just banking, right? We have many different players, and actually a lot of these new players not sit outside, but may be hybrid type organizations that don't classically fit within money service bureaus or financial institution. So actually the regulatory space can be a bit unclear. And yet at the same time, many countries or governments are trying to encourage something called open banking and trying to encourage innovation, right? We want new products and services. We want our digital apps. We don't want to just be going into a branch to make payments. Those days are long gone. So I think that there's that constant challenge, but I'd argue we've always had that challenge. Regulators have always had to evolve their regulations to meet developments in the industry. Banks and institutions have had to develop products and services. Risk associated, there's still the classic ones, right? So when data is shared, how is that data shared? And what is technical capabilities for people to access that site? So it's a bit like when you log on to online banking, that in itself is a potential vulnerability. So anywhere where there's an online footprint, that's the vulnerability. And again, the sharing of data between those institutions. And I know, again, Stephen talked a little bit about some of the data protection and privacy regulations. These are actually inherently important to cybersecurity because you're placing obligations on institutions to protect data. And I think one of the key things, data is now an asset. Information is something that cyber criminals will trade for profit. It's not just going directly for the money. An attack can play out months or years later. So any data that can link to an individual, personal information, and tie it to financial information is going to be highly valuable for cyber criminals. What you hope is that these payment gateways and these information sharing services or these aggregators of financial information take it upon themselves as a responsible company. And I talked a little bit about ransomware trust and how embarrassing a cyber attack, which I didn't really get onto it, but it's, you know, those cyber attacks can be devastating for a company because you lose trust. And I think longer term, you have to take it upon themselves to meet the highest security standard in terms of data protection and embedding security when they're doing their known product and service, because otherwise they won't survive. So I think there's so many issues here, actually. There's a bit of responsibility for organizations, and regulators will catch up, but you don't want to wait for that, right? And data and financial information will be targeted. So they should assume that they'll be of interest. I hope that talked about it.
Thanks, Adam. I think you've certainly covered it. I did think that your banking knowledge and expertise would be helpful. And just if I can just add to the warning that you've issued, Adam, one of the key types of investigations that we're doing at the moment is data leaks and data breaches. And the breaches are where, you know, there's external organizations hacking the company. And the leaks are where internal employees are selling to marketing companies. And as Adam indicated, data is so important. So my message to all of the delegates out there is control access to your own data, protect yourself and your organization, make sure that you change passwords regularly, make sure that you don't click on those malicious links, and make sure that you're only working with legitimate websites. So verify and protect yourselves. And the big message to everyone as well is to make sure that you've got a cybersecurity policy for your organization and do a cyber risk assessment, you know, see where your vulnerabilities are. These are all services that you can adopt proactively. And if you do nothing, you will become a target. Thank you.
Thank you very much, Steve and Adam. Unfortunately, everything that is good must come to an end. And I realize this conversation, we probably did it an injustice by giving it just 90 minutes. It's worth half a day just deliberating and also considering all the things that can go wrong and the mitigants that we need to take. So thank you very much to our participants, our keynote speaker, Justice Okoa. Thank you very much. I've seen a lot of comments just thanking you for gracing our event today. So we are very privileged to have had you, Adam, Steve, Gibbs. Thank you very much. And also to our background supporters on sound and video. So we look forward to further engagement. This is not the end of this conversation. We hope to have many more future engagements. And I would like to take this opportunity to wish us a lovely day to everyone. Bye.
Thanks, everyone. Bye-bye.
Thank you.
Thank you, Lady Justice. Bye-bye.
Thank you so much.